Okay, so just for the recording purposes, sorry, I'm quickly going to rehash what I just said. So if there is an improvement or modification or addition to an invention where there is already an existing application for a patent or an already granted patent, you are able to file a application for patent of addition to any improvement or modification or addition to the parent patent itself, to the invention that is subject to that patent. And the period for which that patent of addition exists is the same, or the duration of the term of the parent patent. And as I said, the benefit of filing the patent of addition is that there are no renewal fees payable. So instead of filing a separate new application as opposed to a patent of addition, you have that benefit of not having to pay the renewal fees and to go through all the prosecution again in South Africa. Unless the parent patent is revoked and the patent might be surrendered by the patentee. In that case, the patent of addition will become the independent patent, and renewal fees will then become payable on that patent of addition. Okay, we've already covered most of what has been discussed in terms of the renewal fees for the patent of addition. What is important to note is that if you file a patent of addition while the application is pending for the main invention, the patent office is not allowed to accept the patent of addition before the independent patent application has been accepted. So it needs to follow the correct order of the independent patent application being accepted first, whereafter the patent of addition may then be accepted. What's also interesting to note is that once the patent of addition is granted, that serves as evidence that the invention is proper subject matter for a patent of addition and cannot be refused on the ground that it does not involve an inventive step. So remember the requirements of patentability, which we rehashed quite a bit yesterday, was the novelty, inventiveness, and also the utility requirements. So in the case of where you file for a patent of addition, that additional subject matter or modification doesn't need to meet this inventiveness requirement. Also important to note that the independent patent and the patent of addition, although separate patents, the patent of addition is also issued with its own official number, but they are joined at the hip. So you're not able to assign the one without the other. So in the case where somebody is interested in purchasing the patent from you, you have to then assign the patent of addition with the parent patent. Is that clear to everyone? Are there any questions on patents of addition?
Marco, I need some clarity. It's Kangwell.
Yes, Kangwell.
Are you well?
I'm well, thank you. And yourself?
Good. Listen, when we talk of patents of addition, is it kind of separate patent in terms of you are going to get a new patent number and a new registration, those kind of things?
Yes, so it is a separate application that is made with its own official number issued to it, and once it is published, that will be the grant number of it as well. So there are two separate patent or application numbers for the independent patent and the patent of addition. The only difference is that you're not able to assign the two separately. So although they are separate, they are in some manner joined as well, because the subject matter is related to that of the independent patent. It's just some modification or addition that's been made. So yes, they are seen as two separate applications or 2 separate patents, whatever the stage may be. But the only thing is you're not able to assign them separately. They have to be sold or transferred separately.
But when you deal with a client, how will you, because now I'm thinking that how different is it if you were to file a separate application?
So the benefit of doing this is because there's no renewal fees payable on the patent of addition. So that's the one benefit. The second benefit is that you don't need to prove inventiveness. So the addition that you're making to the already existing invention doesn't need to go beyond what's already in the prior art, because remember, this parent patent will be considered prior art. So you don't need to prove that there is inventiveness for the subject matter which forms part of the patent of addition.
Okay, thank you.
Okay, no problem. Are there any other additional questions that you might have for patents of addition? Just so that you know, as of from a practical point of view, when the patent of addition is lodged at the patent office, the register page will also indicate on it that it is a patent of addition to the parent patent. So you are able to see from the patent register that there is a link between the 2 patents. Okay, so another form of patent that can be filed in South Africa is what is known as a divisional application. Now, you may recall yesterday afternoon, we briefly discussed that the claims of a patent can relate to a single invention only. And the Patents Act also says that a patent may be granted for one invention. However, there's no recourse to somebody that is prejudiced by this to bring recourse against a patent that comprises more than one invention. But this might be different across the world, this requirement. And often a patent document does comprise more than one invention. Although they might be related, it can be considered a separate invention. And often the clients will then receive an objection by the patent offices across the world that your patent comprises of more than one invention, and they'll raise a unity of invention objection, which is what it's referred to. And in cases like that, what the applicant is able to do is to file a divisional patent application. And what that does is it basically divides the existing patent application into 2 patent applications, where you have the existing patent application and you will amend it in such a way that it is directed to only one of the inventions. And you'll file your second application, which is your divisional application, which will then contain the claims directed to the second invention. So you're basically splitting up one patent application into 2. So you'll have the parent and a divisional application. And that's just the claims that will be different between the 2 applications. What's very important to note is that when you do file a divisional application, you have to file the divisional application before the parent, so the original application, before that original application is accepted, you have to file the divisional application. So just keep in mind these different timelines. So don't confuse a patent of addition where there's matter being added and the patent of addition being filed at any stage in the life of the application or of the patent. But for the divisional application, you have to file it before the independent or parent patent is accepted. And this is merely just to divide out the inventions that are the subject of the parent patent application. Is everyone following what I'm on about? Okay, good. And what a person will do is you'll antedate the filing date of the divisional application. So when you lodge a divisional patent application, you will antedate the filing date of that divisional application to the same filing date of the parent patent. And what this allows is for you to still have your valid claims to priority. So you'll submit a request to the Patent Office with a divisional application, requesting that the application be antedated to the filing date of the parent application. So the term of the divisional application will be the same as that of the parent as well. The nice thing about having a divisional application is that if there is ever an attack on the inventions, you won't have both invalidated in one application because there are two separate patents that will be granted eventually. So each one will have to be attacked independently. And it also just avoids any clarity issue, because if it does arise in court, although you can't revoke a patent on the basis that it comprises more than one invention, it may confuse the court as to what does the invention actually relate to. Is there not some clarity issue? And clarity is one of the grounds of revocation. But that is debatable. The courts have never addressed that, and whether the courts will ever view it in that way is also debatable. Some have the view, because there might be independent claims in a patent, that it isn't really a lack of clarity, and it should be acceptable, but it is a subject that's open to debate. An important case that dealt with divisional applications or divisional patents was the Pharmadynamics case versus Bayer Pharma, where the court just set out what the requirements are for a divisional application in terms of the claims. And what they said is that the claims of the divisional application cannot be the same as that of the parent application. So they have to be, they're not allowed to be coterminous, was a word that was used by the court, which basically just means that you cannot have the same set of claims for the parent and the divisional. And it doesn't make sense to have that, because what you're trying to achieve is separate rights for separate inventions. So it's nonsensical to have a divisional that has the exact set of claims, because you're duplicating work that's already been done. But there may, however, be an overlap between the claims. And it's also possible for the claims of the divisional application to be wider in scope than that of the parent patent. Then you may recall that with a patent of addition, the requirement of inventiveness falls out of the picture. There's no need to prove inventiveness for patent of addition. On the other hand, when it comes to a divisional application, it's not possible to invalidate it on the ground that it is not novel. Any questions that you might have on divisional patent applications before we move along? Hi, Kimberly.
Hi, Marco. I'm just wondering about the wider, it's a bit confusing that you're dividing the application, but you can widen the scope. How, can you maybe just add a bit more detail?
Elaborate on that. Okay, so as we said, that it can comprise two inventions. So what can happen is that they may add or amend the claims of the divisional application in such a manner that it broadens the scope of protection. So looking at the separate application, if this makes sense to you, I'm trying to think of the best way to put it. Let me think about it and come back to you on this, okay? And just so that I can put it in a way that's clearly understandable. I think after our break, I'll touch on that a bit more, if that's okay.
Thank you.
Nonkosi, you also have a question.
Yes, Marco.
Yes.
If you say it cannot be invalidated on the basis of novelty, would the parent application not form part of the prior art?
So because you're antedating the divisional application, it doesn't form part of the prior art because it will have the same filing date as the parent application. And it will still claim the same priority dates of the parent application. So that's why it doesn't form part of the prior art. That should clear it up, I think. Estella, you also have a question? Stella, I can't hear you. Your microphone is unmute. Stella, I'm sorry, we can't hear you. No, okay. Sorry, Stella. Maybe see if you can sort out the issues and I'll answer your question as we move on. And this divisional applications occur quite often in practice where the clients seek to divide out an application that comprises more than one invention. It's quite a common occurrence in practice. Okay, if we just then move on to the term of a patent in terms of section 46(1), as you all know by now, the duration of the patent is 20 years from the date of application. And for a convention application, so that follows the Paris Convention route or a non-convention application just filed directly in South Africa, the 20-year will start from the filing date of that application. But you may recall that for national phase patent applications, after our discussion yesterday, is that the effective date will be from the international filing date of the PCT application. So it's not the filing date of the national phase patent application, but that of the PCT filing date. Okay, but in order to ensure that your patent remains in force, you obviously need to pay the renewal fees that are due to the government in order to ensure that the patent is in effect and in force. And this is covered largely by section 46(2). And what it finds is that the first renewal fee that is payable on a patent in South Africa is the 3rd year from the filing date. Now remember, the filing date differs for convention applications and for national phase applications. So it will be 3 years from either the international filing date for a national phase patent application or 3 years from the local filing date for a convention or non-convention application. Okay, but you are provided with a 6-month grace period within which to pay the renewal fee. So if you haven't paid it by that 3rd year, you can pay it within 6 months from the deadline. So during that period, so let's have a look at this diagram in front of us. So the 3 years is calculated from the application date of a year. The patent has proceeded to grant, and within 3 years from this application date, your first renewal fee is due for payment. If you do not attend to the payment within that 6-month period, the patent is deemed to have lapsed. In this period over a year, it is only provisionally lapsed. But if it is not paid before the 6-month period, then it has lapsed completely. So you've lost your rights if you haven't attended to the payment by the 6-month grace period. So renewal fees are only due once the patent has proceeded to grant. So you only need to start paying once a patent has proceeded to grant. But the problem is that in some instances, if grant occurs more than 3 years after that, then those renewal fees have to be paid on the date of grant without the extension available to them for a convention application. So in practice, what is done and what is advisable is to pay the renewal fees as they become due, irrespective of the status of the application or patent. So if it's still pending, we generally always advise the clients still to pay the renewal fee when it is due and not to wait until the date of grant. Because if they wait until the date of grant and they miss the payment of the renewal fees that are due or outstanding during the pendency of the application, then it could potentially lead to a lapse of rights if they miss those renewal fee payments. And this is basically what we've just discussed now in terms of Regulation 48. So any renewal fee that is outstanding by the time the patent proceeds to grant need to be paid at the date of grant. Okay, but then to complicate matters a bit further, we're going to look at national phase applications and the additional provisions that relate to national phase patent applications. If the patent application for a national phase application proceeds to grant more than 33 months after the international filing date, in that instance, the applicant is provided with a 6-month grace period where no late fines are payable. So if we just go back one step, at this stage, for this, to make use of this 6-month grace period, you have to pay late fines to the patent office. But in this instance, where the patent proceeds to grant more than 33 months after the international filing date, the applicant or patentee at that time is allowed a 6-month grace period without the payment of late fines. But then regulation, this one that deals with a 6-month extension, also comes into play. So in addition to that 6 months that they are given, a no late fine payable grace period, there's an additional 6 months, which is subject to late fines. So what that basically means is if the renewal fees, or if the patent proceeded to grant more than 33 months after the international filing date, they have a year within which to pay any of the outstanding renewal fees that were due on that application. Again, I'm not going to read through these regulations because the wording is extremely confusing and it can be quite difficult to follow what the regulation 67L actually says, but that is the crux of it. Okay. Let me just double check my notes as well. Okay, is everybody happy with the payment of renewal fees? If grant occurs before I take the question, if grant occurs before 33 months for national phase patent application, the renewals become due as they normally would. Okay, so there's no real confusion about that. It's just if grant occurs more than 33 months after the international filing date, where you are then required to pay all the outstanding renewal fees within a year from the date of grant. There was somebody with a question earlier. Wasim? Check. I see there's something in the chat here as well. Sorry.
Hi.
Yes.
Can you hear me?
Yes, I can hear you.
I just needed to find out, as a matter of interest, if the patent did lapse and you've missed the date and you've missed the grace period and everything else, is that patent able to be infringed by another party immediately once that happens, or?
Yes, so then it's in the public domain, but there is recourse to the patentee if the patent has lapsed. And we'll touch on that a little bit later on to date, where you can apply for the restoration of the patent where the renewal fee was missed. But there are certain requirements that need to be met. But we definitely
and
going
then,
to touch on that. It's an important one.
Okay, thanks. And then the other thing, one other short question. Is this something that generally the patent attorneys handle, or would the company that's holding the patent generally?
Yes, normally most patent attorneys have some system that is able to keep track of when the renewal fees are due and to provide reminders to the clients. There's several agencies across the world as well, which a lot of people actually make use of, such as CPA or Denemeyer, that focus purely on the maintenance of the patents. So it's possible for people to subscribe to one of those services as well.
Just so that it doesn't lapse. Okay, thanks so much.
Just ensure, no problem. Nomkosi, I'm sorry to see that you are completely lost. Nomkosi's even disappeared. Let's see if she comes back. Are you fine? Your microphone is off.
I'm here, Marco. I'm just trying to figure it out. I'll deal with it in the question and answer session that you have later on.
Okay, perfect. Thanks. Okay, I wouldn't be too concerned with these illustrations because they are slightly confusing. It's things that I've taken notes of throughout my years in practice, and it can be a bit confusing. So don't be too concerned about it. You can use it as a guide, but I don't want it to confuse you too much. Are we all still good to carry on? Yes. Okay, so we're going to move on to the next section, which is the corrections and amendments of patent applications and patents. And this is something that is used in practice all the time. So a very important part of the work that patent attorneys deal with. And this is in terms of section 50. We can have a look at the corrections first of all. So in terms of section 50, there are various corrections that are allowed to be made to an application or to a patent. And the first is that of a clerical error. So where a clerical error exists in the application, you may request that that error be corrected by way of an application in terms of section 51A. Section 51A also makes for the provision of a correction where there is an error in the translation of the specification or any document in support of that application. Because remember, it does often occur where you will be required to file a translation into English of the specification if it was filed in a language other than English across the world. So when you lodge the application in South Africa, where the original application was filed in a different language, you will file the foreign language specification, but with that you will also lodge the translation. But obviously errors may arise during this translation procedure that has taken place from the foreign language into English. And section 51A makes provision for that error to be corrected. Okay, so two instances in terms of section 51A where an error can be corrected. One, it being a clerical error, and two, being an error in translation. And a lot of you might wonder, but what is an actual clerical error? And this was held in several cases. So if we can just jump to the cases in front of us. The first case that dealt with what a clerical error is the Macaulay Corporation case. Who can remember where this case arose yesterday. We discussed this case yesterday as well. Can anybody remember what this case also dealt with yesterday? No, no one.
Novelty. Novelty.
No, that novelty was Gentiruco.
Okay.
Any other ideas? No, you can't go look back at your notes now. I'm watching. Okay, it dealt with what defines public. Sorry, John, I may have jumped your answer there, but it dealt with what is the scope of the public. Hi, Ben. Yes.
Sorry, Marco, I was going to answer your question about Macaulay, but then I see you went ahead with it.
Yes, sorry, I didn't see your hand there. Were you going to say what I mentioned?
Yeah, just that it dealt with prior art and how that pertained to novelty.
Yes, okay, that's right. Okay, thank you. Okay, so Macaulay also then dealt with what is considered a clerical error. And yeah, they held that a clerical error is a careless error because it is unintentional. And because it is an unintentional error, it is considered a clerical error. They went on further to say that it would still be a clerical error if the error was inadvertently made in an earlier draft and was unintentionally transferred to a later draft. So they're saying that a clerical error is an error that occurred out of carelessness and which was unintentional. Then the next case, hi Kagiso.
Hi, Marco. I just wanted to understand how you would explain, for example, even if in your application you had made a quote-unquote clerical error, how would you prove that it was a mistake?
A clerical error.
Yeah.
So there's no requirement for the correction of clerical errors where you're lodging it under it depends on the situation though as well. So in practice, it often arises that an inventor, for instance, was left out of the application documents, where somebody didn't include the inventor as an inventor in the application documents. And it then later transpires that the inventor should have been listed. In that case, you've got to determine, was that actually a clerical error that occurred? You know, was it something out of copying and sheer ignorance where this person was omitted and they should have been listed there? Or did it during some inquiry into the inventorship of the invention only then come to light that the inventor actually contributed to the invention? So I have two different scenarios in this case. And in that application that you make, I always add some reasons as to why I'm justifying this request. It's sometimes merely just acceptable to state that it is a clerical error, provided you as the attorney know that this is the facts behind what led to the error. But if it is something in the specification, for instance, where perhaps the orientation of a chemical, for instance, if you're thinking of chemistry, where the stereoisomer should be a different orientation, and that was purely a clerical error that was made when drafting the specification, then you would indicate that change to the patent office by showing where the change is being made in the specification, and then also including a copy of the corrected specification or that page that is being corrected. And in most cases, you will also provide reasons as to why you are making that change. But the patent office doesn't go into a full inquiry. The only problem is that it can later down the line come to some administration violation by the registrar for allowing it. So the registrar might be taken on review for allowing a correction that shouldn't have been allowed. Okay, but in most cases, the Patent Office will allow every request that you submit to them, but the onus is on the applicant to ensure that it is correct and to ensure that it doesn't later lead to a situation where the registrar needs to be taken on review. Okay. So if we then move on to the second case, this was the Hokuriku Pharmaceutical versus Cipla MedPro case. And yeah, the court departed from the previous ruling, and they held that it is an error that is made in a mechanical process, even if it is out of sheer ignorance. So in the case where you have possibly, recorded the wording of the specification and your secretary types out what you have recorded, so dictatyping, and in that there was some mechanical process in her typing where this error arose. But if we just look at the extract from the case, it said that a clerical error occurs where a person, either of his own volition or under the instruction of another, intends to write something and by inadvertence omits to write it or writes something different. Okay. So you can see from the previous case, it was held to be unintentional, but in the Hokuriku case, there isn't really that requirement of it being unintentional. Then the last case that dealt with the corrections was the Pfizer versus Cipla MedPro again. And yeah, it was held that a clerical error is a mindless error that occurs through inadvertence and falls within the dictum of the Macaulay case. So they then basically agreed with what was found in the Macaulay case, that it should be an error which is carelessly made or inadvertently made by either writing or copying, or an error in a mechanical process. So they broadened the definition quite a bit by taking into account that which was held in the Macaulay case and the Hokuriku case. And the reason why it's important to make this distinction is because when you make your application to the registrar for the correction, you need to consider whether it is a clerical error, and because your application will be made in terms of this provision, section 51A. But you'll see that section 51B also provides for the amendment of any document where no express provision is made. So you need to make that distinction between what provisions you are relying on in terms of your application. And if we look at the inventorship issue again that I used as an example earlier, if it was a clerical error for the inventor being omitted, then you would rely on section 51A. But if it only comes to light later on where it was clearly not a clerical error, it was just unknown at the time the application was made that this inventor had actually contributed to the subject matter, then that's clearly not a clerical error. It wasn't an unintentional error that occurred. It's just that there wasn't proper due diligence that was followed, which isn't considered a clerical error. And in that case, you would then rely on section 51B to amend the application documents to include an inventor in the application. Okay. And Hokuriku specifically dealt with the omission of inventors as well. Hi, Kimberly.
Hi, Marco. I'm just wondering, with the section 50, is that an option if someone is trying to revoke a patent on the grounds that an inventor wasn't included? Can a person just amend the patent to include it, or would it not apply and the patent would just be revoked?
Yeah, so look, if you're looking at the revocation provisions, there's no express provision that the patent can be revoked due to the omission of an inventor. But what can lead to a ground of revocation is if that chain of title isn't shown. And also remember, yesterday we discussed the P3 as well, where the inventors are listed. And on the P3, there's probably omission of that inventor, and you're declaring they are inventors. But it's at that time that that declaration is made. So if it only comes to light after that declaration is made, you can't rely on that provision to revoke the patent as well. But you can possibly, on the chain of entitlement to the applicant, rely on that. And in that case, you would most likely be able to make an amendment to the application documents to include it. I'm not sure it's ever been relied on. And you'll see when we move on to the amendment section next, that there is provision for the amendment of the specification itself. So not necessarily the formality documents, but to the specification during litigation proceedings. So just to be aware of that. But you would most likely be able to rely on this provision to amend it. What's also very interesting while we're on this topic of inventorship is that the countries have also found differently as to who should be listed as an inventor, who is considered an inventor. So in America, for instance, the Americans have held that an inventor should be listed as an inventor if they have contributed to the subject matter of the claims. So what is provided for in the claimed subject matter. But the South African courts have followed the English case, which is the Stenalco case. It's a British case. And our courts have referred to that case. And that case basically held that the courts need to consider the invention as a whole, not just the claim subject matter. So any contribution that was made by an inventor, whether it be just to what is disclosed in the specification or in the claim subject matter, should be listed as an inventor. And you can see this can lead to a problem where in America, they might feel an inventor shouldn't be listed, but in South Africa, we should have an inventor listed. But that's a bit beyond the scope of what's required for you to know. Yeah, it's just out of interest. Let's just have a quick look. Do you think we should break for until 10 o'clock? I think we can take a quick break until 10 o'clock. Yes. Yeah. Okay, so I'll see you all at 10 o'clock again, and then we can carry on with the amendment section. Okay, welcome back, everybody. I think we can move on to section 51 that deals with amendments. Okay, so the Patents Act makes provision for various types or various stages at which an amendment may be made. The first being the amendment of a provisional patent application and the specification thereof, as well as the amendment of a patent application. So that is when the application is pending and that is prior to the application proceeding to grant. So any amendment that is made before publication in the Patent Journal of the Acceptance. Then there's also the allowance for an amendment to be made after the grant of the patent, and that can be at any time after grant. And then also provision is made for an amendment during the course of legal proceedings. So before the Court of the Commission of Patents, there is also an opportunity during the legal proceedings to make an amendment to the patent at that time. If we quickly have a look at section 51 and regulations 52 and 53, it says that mentions that an application for an amendment, when making that application, you need to show the nature of the amendment. So you need to set out what it is that you are amending. And in practice, this is done by basically using track changes. So any deletion will be struck out, any insertion will be underlined within the document. And that is basically what is referred to in practice as your reds of the amendment. So your reds. That's not something from the Act, that's just what it's referred to in practice, where you actually indicate what the changes are that are being made. Whether you're deleting certain words or adding anything to the specification. And then in your application for the amendment, you also need to provide the reasons why an amendment is being made. Okay, so you need to provide the full reasons for the amendment. And there can be various reasons for this. Often the patent specification contains non-metric units and an amendment is made to bring it into line with the unit system used in South Africa. It could be that there was prior art that was brought out in examination that could negatively affect the patent rights in South Africa, and that you wish to amend the patent specification to overcome those objections to ensure that the patent is in a valid form once it proceeds to grant or even after grant. So your reason there will be to overcome the prior art and to ensure the validity of the application or patent. Okay, so for all these various forms of amendments that need to be made, you need to show what the amendment is that you are introducing or making, and then you also need to provide the full reasons as to why the specific amendment is being made. And just to note that any amendment to a provisional application can only be to correct any mistake, which includes an obvious mistake. And that is the only form of amendment that can be made to a provisional patent specification, where there is a mistake in the specification that is, or that can be an obvious mistake as well, that you wish to amend. So you can't introduce new matter into your provisional specification by way of an amendment. So you can't add to what it is that you've already disclosed in the provisional specification. It's only to correct errors. So what amendments can be made to a pending patent application? And this is dealt with in terms of section 51.6. And the Act sets out that no amendment of the specification will be allowed if it introduces new matter or matter not in substance disclosed. And the second is that the specification would include a claim which is not fairly based on subject matter disclosed in the specification before the amendment. So again, as I mentioned with the provisional specification, you can't add matter which you haven't previously disclosed in the specification. So you can't add new matter and try to broaden the rights by way of an amendment. So it's not permissible to add new matter. And you also can't introduce a claim into the patent specification where the subject matter of that claim hasn't been fairly based or isn't fairly based on what you have disclosed in that specification. Okay. So what it is that you are claiming has to form part of what it is that you have disclosed in the specification. So you can't add claims that are not fairly based on what is disclosed in the specification. And as I said, the application for an amendment of a pending application is made on the Form P12 in terms of the patent regulation. So just something to note that it's a Form P12 that is used for a pending application. For a provisional application, in terms of Section 51.5, it is a P11. If you do wish to amend the granted patent, so it can again come to light that there is prior art that was never disclosed or discovered during the prosecution of the application, but only comes to light after the grant of the patent. You are able to amend the granted patent as well in terms of sections 51.7, 2 and 3. And this amendment is made using the Form P13. So they follow a nice sequence, 11, 12, and 13. And the requirements for a granted patent are the same as for a pending application where you can't add new matter or you can't make an amendment which is not fairly based on the specification. But there is a further burden in that the amendment must fall wholly within the scope of the claims already included before the amendment. So you can't add something which hasn't already been claimed previously. You can possibly delete a claim, but you cannot widen the scope of your protection. So you can't broaden the protection that you're trying to seek. Okay, so in addition to the two requirements for pending application, there's this third requirement which is quite onerous in that you can't broaden the scope of protection. And in addition to an application for an amendment of a granted patent, you also need to publish or advertise the amendment in the patent journal. So if you are amending the patent, you need to advertise it in the patent journal. And this amendment is then open to opposition for a period of 2 months in terms of Regulation 53. So anyone is able to oppose that amendment that will be dealt with by the Commissioner of Patents. Just so that you don't confuse the two, there are two legal persons involved in the entire process of patents. The one being the Registrar of Patents, who is the manager of the patent office and deals with the administrative aspects of patents. The Commissioner of Patents, on the other hand, is the High Court judge that is appointed as a Commissioner of Patents. And this is just a High Court judge that sits in the Pretoria High Court. So two different bodies. So whenever you are dealing with certain matters in the Act, you need to determine who it is that will actually deal with the matter. So in this case, where the amendment is being made and it is opposed by a third party, that opposition to the amendment needs to be brought to the Commissioner. So it will be an application that is made to the High Court in Pretoria. Okay, because the Court of the Commissioner of Patents is a specialized court, but it is sitting at the High Court in Pretoria. That's the only court in South Africa that has jurisdiction to hear patent matters. Okay, so just be very careful not to confuse the Registrar of Patents and the Commissioner of Patents. excuse me. You'll see later on when we're dealing with the restoration application. The restoration application is brought before the Registrar of Patents. So it can cause confusion to those who are unfamiliar with the proceedings. Then, as I mentioned earlier as well, you are able to amend the patent during the course of legal proceedings in terms of section 1519. And this is where, during the course of any legal proceedings that involve the patent or the application before the court, a request can be made to the court for the amendment of the patent or the application. So again, it's an application made to the Commissioner of Patents and not the Registrar, because the whole process is taking place before the Commissioner of Patents. Are there any questions that you might have on amendments? Okay, so as you'll recall from the requirements for an amendment to a patent or a pending application for a patent, you're not allowed to introduce new matter, but there are instances where the applicant does wish to introduce new matter, but it is not allowable in terms of the amendment provisions. And in that case, in terms of section 51A, you can file what is known as a supplementary disclosure. And this is where the amendment, as I mentioned, may not be allowed by a reason of the prohibitions in terms of subsection 6, which is that of the new matter. However, that new matter, sorry, my phone is talking to me. However, that new matter must be fairly associated, so not necessarily based. It doesn't need to form part of what's already been disclosed, but there must be an association, a link, and a fair link between what the new subject matter is and what has been disclosed in the patent application. So a request can be made for the supplementary disclosure to be allowed for the new matter that you wish to add to the patent application, provided the new matter is fairly associated with the subject matter of the application and what is disclosed in the patent application. And also, the supplementary disclosure needs to be lodged before the publication of the acceptance. So a supplementary disclosure is only available to an applicant before the application proceeds to grant. And as we just highlight here, the new matter may be introduced by way of a supplementary disclosure, which is then attached to the specification and dated with the date on which the application for that supplementary disclosure is made. Kimberly, you have a question?
I'm just wondering, what's the difference between the supplementary disclosure and the patent of addition?
Okay, so the patent of addition is a completely new application that is made where you are granted a new official number, and that's generally only for a modification that is made to the already existing invention. So, you know, it's, if you're possibly modifying the handle of this mug, for instance, the shape of this mug, just as a very basic example, whereas for a supplementary disclosure, if there was no mug and you're now adding a handle to the mug, that is completely new matter that is being added to the specification. So yes, it's an important question, that, but the supplementary disclosure forms part of the already existing patent application and patent specification. It's basically an annexure to the patent specification, whereas with the patent of addition, it's an additional patent that is being granted to the proprietor of that invention. Okay, whereas yeah, it forms part of that application, and it's just, as we say, a mechanism by which to add new matter to the spec. And just to note the points that it must be fairly associated with the invention, what has been disclosed, and it must be filed before grant. So with the patent of addition, you can file a patent of addition at any time, whether the application is pending or whether it has proceeded to grant already. But for the supplementary disclosure, it has to occur before grant.
Marco,
Yes.
the definition of fairly be associated is basically that it must be linked with the original specification.
That's correct. Yes. So there must be a link between what it is that you're disclosing. It can't be a whole new invention, but there must be some link between what you have disclosed in the original patent specification. Okay. And then in terms of the priority date of that new subject matter, the priority date of that subject matter that is added will be the date on which the application is lodged for the supplementary disclosure. Okay. So Kimberly, you were right. You can use the different mechanisms, but you have to assess what is the most beneficial and what it is that you're actually looking to obtain. And more specifically, the time periods as well, where these changes are being made. If you worked through the exam paper from last year, you would have seen that there was a question on supplementary disclosures and patents of additions, asking you to set out the understanding for both of those. So important sections to note. So the Act deals with amendments in other places as well, and specifically in section 43F 3M. And if we go, if we consider the slide that we worked through yesterday of the international phase of the PCT, where the applicant is provided with the opportunities to make amendments during the international phase. So you may recall that you can amend it after you've received the search report and written opinion. You'll then submit an amendment in terms of Article 19 of the PCT, which allows for an amendment to be made once considering the opinion of the examiner during the international phase. But then you can also file your demand where you amend the specification and claims again, and that is provided for in terms of Article 34 of the PCT. But what the South African Patents Act does is it allows for those amendments made during the international phase to be deemed to be an amendment made in South Africa. So in a nutshell, any amendment that is made during the international phase is deemed to be an amendment that is allowed in South Africa. So it forms part of the South African application as well. Okay, everyone understand that? Happy with that? Good. Then if we look at section 52, this deals with the rectification of the registrar, where the registrar may also order that the register be rectified by making any amendment or deletion or correction to the registrar, and he can do this out of his own volition or on request that is made to him. Okay, everyone happy with the amendments and corrections section? Then we can move on. Okay, so we've dealt a lot about how to obtain a patent, what the requirements are to obtain a patent, how to apply for the patent, what different types of patents you can apply for, how you can correct them, how you can amend them, but who can actually apply for a patent. And this is dealt with in terms of section 27.1, and it's probably where we should have started off with, who can file an application for a patent. And section 27.1 says that a patent for an invention may be made by the inventor or any person that acquires the rights from the inventor to the invention. So if the inventor hasn't assigned his rights, then the inventor needs to make the application for the patent. However, if the inventor has assigned the rights to a third party, then it is the assignee that needs to file the application for the patent and is the person entitled to make that application. But as you may recall yesterday, proof of the transfer of rights from the inventor to the applicant has to be shown. And it often happens that even before the application is filed in South Africa, that invention has been transferred several times. So it could have been from the inventor to party X, and party X then assigned it to party Z. And you need to show that entire chain and transfer of the rights from the inventor to the current applicant. So it's not just proof from the most recent step. You need to indicate the entitlement to the current applicant, however many transfers there have been of the rights from the inventors. And this is done either by way of a deed of assignment of invention, so a written document where you have transferred the rights, so a contractual agreement where party A transfers all the rights to the invention to party B. The assignment can also occur by way of the contract of employment, as we discussed yesterday. I'm sure if a lot of you look at your employment contracts, there is likely to be a clause within your employment contract that states that all development or inventions made during the course of your employment are vested with the employer. So those rights automatically vest with the employer. Then also a contract to do something where you have contracted a third party to do development or research for you, where that contract also stipulates the assignment of rights. Then there are also statutory provisions that allow for the automatic assignment of rights, and this is particularly so in some of the foreign countries. If you look at the United Kingdom, their Patents Act has a specific provision that all inventions made during the course and scope of employment are transferred to the employer. And the same with Germany. Their Intellectual Property Act also provides for an assignment of rights in certain instances from the inventor automatically. So in those cases, there won't necessarily be a deed of assignment, but it is regulated by statute. And if we look at South Africa, if we look at the Intellectual Property Rights from Publicly Financed Research and Development Act, that is also in cases where there is development at publicly financed institutions. So some universities or the CSIR, for instance, where somebody is employed to develop and research a specific invention, those rights automatically vest to that institution. Another problem that we often come across is where an inventor has deceased, has passed away. Then you need to look at the succession of how that person's estate is dissolved and where those rights to that invention would have moved to. So would it be to his heirs? Would it have been to the wife? And in that case, you need to also obtain proof of whether the person either had a will or whether it was by intestate succession. And in that case, you would probably need the executor of the estate to provide some documentary evidence that this person's estate would have been bequeathed to the wife, for instance, in this case. So just something to consider. It does happen in practice. And again, just for those that are in patent practice, it also arises in situations where there is a disagreement between parties, where an employer and employee don't like each other anymore. The person has left the employer of the company and they are recalcitrant and refuse to sign any documents proving the assignment of the rights. And what we normally do in practice in that case is to obtain affidavits from the employer setting out what their company policy is in terms of any IP that is developed by that company, to submit any documents they might have in support of that, and that they attest to being the rightful owner of the invention. So it is possible to overcome that hurdle if an inventor is recalcitrant and refuses to sign any document necessary. Okay, if we move on to section 29, the Act provides that if there's no agreement to the contrary and there are joint owners in an application, so if there's more than one person that is an applicant for an invention and for the patent application, then those owners have an equal and undivided share in the application. So they basically own it 50-50. And none of them may deal in the application in any way without the consent of the other party. The only time where they may act without the consent of the other party is where the application or patent is about to lapse and they then instruct the party to pay or instruct the payment of renewal fees. So you are allowed to pay the renewal fees without the other party consenting to that. But other than that, you need the agreement of both parties in order to deal with the application in any way. So it's not possible for one party to sell the patent or to assign the patent to a third party without the consent of the other party. Then it obviously does occur where a relationship sour and disputes arise in terms of the rights that exist and the rights that exist in and to the application. And if there is a dispute that arises, that dispute needs to be addressed by the Commissioner of the Patents to decide on the matter. So an application will be made to the High Court or the Commission of Patents to deal with any dispute that may arise between joint applicants. The party bringing the application to the Commissioner of Patents will be liable for the costs and expenses in bringing that application. And after the Commissioner hears the parties, he may then decide that one party assign their rights to the application and the invention to the other party, provided that it is just and equitable. And he can also order that compensation be paid to the party that assigns their rights to the person bringing the application. But the court will always try and preserve the rights into the application. So they'll always want to see that the application does proceed to grant. So they'll always resolve the dispute in a manner which will lead to the preservation of the application and the eventual grant of the patent. So they won't allow it to lapse. They will generally try and ensure that the patent application does proceed to grant and that the rights are preserved. Section 28 deals with very similar provisions as we dealt with in terms of Section 29. But Section 29 is very specific to disputes that arise between applicants and the rights to the application, where Section 28 specifically deals with the rights to the actual invention itself, and who owns the rights to the invention. And again, where there's a dispute that arises between the inventors in this instance, or parties that believe they have rights to the invention, again, the application is made to the Commissioner of Patents to decide on the matter and to hear the arguments presented to the Commissioner. Again, the Commissioner can order the assignment of the invention to whichever party the Commissioner finds is just, and also to allow for the compensation to be made to the aggrieved party. Okay, so that was dealing with the rights to the invention where there's a dispute to the invention. But now if we look at joint ownership of patents, so section 29 dealt with the applications, the joint ownership of applications. Section 49, 1, 2, and 4 deal with joint ownership of patents. And again, as with applications, the Act provides that the owners of the patents, if there's no agreement, will own the rights to the patents in equal and undivided shares. Any patentee may, during infringement proceedings, or if there is, or if one of the patentees is made aware that there is an infringement taking place of the patent, that party may proceed with infringement proceedings, but they need to give notice to every patentee. So every party or every owner of that patent must be notified that one of the parties is proceeding with infringement proceedings. And they then have the option to join as a co-applicant or co-plaintiff in infringement proceedings in order for them to also recover damages. And then again, the same provisions as for an application, the owner is not allowed to deal with the patents in any way without the consent of the other parties. And if you look here, it says to take any steps or institute any proceedings relating to the patent. Well, they are allowed to do that, provided the other parties are given the option to join as co-plaintiffs. If only one of the parties does bring the application for the infringement of the patent and they are successful in the proceedings and damages are awarded, then only that party is awarded with the damages award. So the co-patentees will not be awarded damages unless they are co-plaintiffs in the infringement proceedings. Again, section 49 deals with disputes, which are the same provisions as we've already touched on. So I'm not going to go through this again, but it's pretty much the exact same provisions as we had a look at in section 29 and 28. So at the start of yesterday, I said you must always remember that your patent right is an intangible asset, which is as your house or your car, capable of being sold or transferred. And the same applies to patent rights, where it is capable of being assigned. And its specific provision is made in section 59 of the Act, where the patent is capable of being assigned. However, there is an instance where an assignment is not allowed, and that is in terms of section 59(2), where it states that any condition in a contract of employment. So very important for those of you that are in contract law and that draft contracts, in particular employment contracts, that these provisions in terms of section 59(2) are deemed null and void. And that is where the contract requires that the employee assigns to the employer the invention during the course of employment. Or restricts the rights of an employer in an invention made by him more than 1 year after the termination of the contract of employment. So those provisions are deemed to be null and void. So that is where there is that requirement to assign an invention that would have otherwise been in the course and scope of employment, but that it is done after the employment. So again, section 60 dealing with the assignment, attachment, and hypothecation. In terms of section 60, the applicant again or patentee may assign the rights, but it's very important to note that an assignment of a patent application or patent has to be in writing. You're not able to assign a patent application or patent by virtue of a verbal agreement. The assignment has to be in writing, which is very important to note. And I think the same provision applies for copyright law as well, where the assignment has to be in writing. You can't verbally assign these rights. What is also important to note that the assignment is not valid between or valid to third parties unless it is recorded in the patent register. So if there is an assignment that has taken place, it is important to record that the assignment has taken place on the patent register rather. And this is done by filing an application using the form P16, where you will set out or request the registrar to allow the assignment or to update the register where the assignment has taken place from party A to party B. And in that application that is being made, you will lodge the supporting documents, which will be the assignment of the patent. And what's also important to remember that if an application or patent has joint owners, you need the consent of one of the parties that is not assigning the patent. So if in the case where party A and party B own the patent and party A is assigning his rights, you need to show that party B has actually consented to party A selling or assigning his rights to a third party. So in that instance, you would need to lodge, in addition to the deed of assignment, some evidence that the other party has consented to that assignment of party A's rights being assigned. And that's usually done by way of a deed of consent, which is just a document that will be signed by the other party attesting to the confirmation and consent of the assignment. Okay. It is important that the assignment be recorded within 6 months of the effective date of the assignment. If it's not recorded within that 6-month period, you are then required to pay late fees for the late recordal of the assignment. So in addition to your form P16, where you are requesting the recordal of the assignment in the register, you also have to request the registrar to allow the late recordal of the assignment. So within 6 months of the assignment, you should attend to the recordal of the assignment at the patent office. It's not mandatory to do so to record an assignment. However, it's not effective between third parties then, and it could be against public interest if the public is not aware as to who the actual proprietor is of a patent. And that's why it is advisable to record the assignment. And if ever you do wish to institute proceedings before the court of the Commissioner of Patents and the registrar is not updated, it doesn't reflect the correct parties and who the correct owner is. So if that assignment was never recorded, they will first be required to record that assignment before proceeding with legal proceedings before the Commissioner of Patents. So it's always better to have your ducks in a row and to attend to this recordal before it does come to a stage where you do need to go to court. Okay, and as I said yesterday as well, it's possible to use a patent as security, so it can either be attached, to secure a debt, or it can be used as security in terms of you seeking a loan or allowing somebody to fulfill a debt that you might owe to them. And that is provided for in terms of Section 62 all the way up to Section 6060. But you can have a look at that in your own time. It's not something that we're going to focus on right now. But it's the same provisions that apply to trademarks and copyright as well, where these rights can be attached in order to secure a debt or to fulfill a debt. Okay, I think before we jump into the next section, we should take another break. Let me just have a quick look at how much we have left to cover. Okay, we're making good progress today. So I think let's break until 11 o'clock and then we can resume at 11. Okay, see you all shortly. Are there any questions that you might have? If there is anyone with questions, you're welcome to ask me in the meantime. Okay, it appears there are no questions, so I'll see you at 11 o'clock again. Hi, welcome back from the break, everyone. We can resume with the next section of the work that deals with the licensing of patents, particularly voluntary licenses as well as compulsory licenses. The first section that we will be looking at, and as you could see from the hot topic yesterday, we were discussing the COVID vaccine and the government's remedies or options that are available to them. Section 56 will probably be one of the options that are available to them where they can compel the proprietor of the patent to grant them with a compulsory license. And that will be done by making an application to the Commissioner of Patents. But in this situation, you would have to indicate that there is an abuse of the patent rights. And the court will need to determine whether the rights are indeed being abused by the patentee. And the rights will be deemed to be abused by the patentee if the invention is not being worked in South Africa. So the patentee is not actually making use of the patent in South Africa. They're not working the patent on a commercial scale or to an adequate extent to meet the demands for the product or process which is subject to the patent. So that is in one instance where the patent will be deemed to be abused if it's actually not being worked in South Africa on a commercial scale or to an adequate extent. And if there is no reason for the non-working of the patent. The second provision where a patent may be deemed to be abused and which one can rely on in order to apply for compulsory license is if the demand is not being met in the Republic to an adequate extent or on reasonable terms. Tied in with that, I'm going to jump to subsection E. So where the demand is being met in South Africa, but it is by way of importation, and where the price charged for the products or process, whatever is subject to the invention, is far more excessive than what the price is in relation to the invention, which is subject to the patent in other countries. So in the one instance, there is an abuse of rights or considered abuse of rights if the demand is not being met. But then on the flip side, where the demand is being met, but it is by way of importation and the cost is excessive in South Africa in relation to the price charged in other countries. If we look at subsection D, in this case, it is where the refusal to grant a license, if somebody has approached the patentee and has requested the grant of a license and they refuse to do so, if that refusal leads to the prejudice of the public interest, then a compulsory license for the patent should be granted. And this is probably the case where the COVID vaccine will fit in best, is if no license is granted for the government to use the patent in South Africa, it would probably be in the public interest that a compulsory license be granted in order for the public not to be prejudiced. Okay, so you can see that there are 4 instances in which an abuse of rights in the patent can occur and where the Commissioner of Patents can be approached for the grant of a compulsory license. But as I mentioned yesterday, there's never been a successful grant of a compulsory license in South Africa. It's quite onerous to prove these requirements that the patent is in fact being abused. Nkosi, you have a question?
Yes, ma'am. The section 56(2)(b) that is deleted was deleted.
Let me quickly have a look for you. On my act. I might not have it in front of me. I'm hoping it's here. It was the 1997 amendment.
Thanks, Marco.
Pleasure. So yes, 1997. That's right. Okay, so as I said, it's quite onerous to prove that there is an abuse of rights, and there hasn't been any success in the grant of the compulsory license. Some are of the view that these provisions have been successful because it has deterred people from refusing voluntary licenses. But on the flip side, it could be that nobody has just ever been successful in application for a compulsory license. Okay, then the patentee or any interested party may oppose the application for the grant of the compulsory license. And this just sets out what the commissioner should consider. So he obviously needs to consider the application on its merits and may order the grant to the applicant of the license on such conditions that the commissioner deems fit. It also gives him obviously the directive to refuse the application if he so chooses. But this is just something that you can read in your own time. It just deals with the provisions and the considerations that the commissioner needs to apply when considering an application for the grant of a compulsory license. Subsection 5 says that the grant of a compulsory shall be non-exclusive. However, it may not be transferable from the licensee, that is. And again, just further provisions that the commissioner may consider, and that he does also have the ability to amend or revoke the license should he deem fit. Again, the commissioner can also award a cost order against the applicant or patentee who opposes the grant of the compulsory license. Again, these are just provisions that you can work through in your own time. They are quite clear. So just for important provisions to note from that section is what are the abuses of a patent, or what are considered an abuse of the patent right, and the instances where you can make an application to the Commissioner of Patent for the grant of a compulsory license. A compulsory license can also be granted in the case of a dependent patent. So the first one that we dealt with was where there has been an abuse of rights. The second instance where a compulsory license can be granted is in terms of a dependent patent. And this will be in a situation where a patentee has been granted the right to a patent, but they're unable to work their patent without infringing that of a pre-existing patent. And in order for them to work their own patent in South Africa, they should have a license from the proprietor of the pre-existing patent in order not to infringe on their patent. And in this case, it is possible to obtain a compulsory license for the dependent patent. So dependent patent would be the one where it needs to be worked without infringing a pre-existing patent. And in this case, the court needs to consider a few things as well. And that is that without the grant of the compulsory license, would it be detrimental to the economy of the country? So they need to consider the economic significance if the patent is not able to be worked in South Africa, and what effect that has in terms of the economic significance. So as you can see there from section 55, subsection 1A, it says that the invention claimed in the dependent patent involves an important technical advance of considerable economic significance in relation to the invention. So it is actually in the best interest of society if that patent is able to be worked in the country due to the important technical advance in technology for that specific technology. But then also, if there is a grant for the compulsory license for the dependent patent, the proprietor of the dependent patent has to cross-license his patent to the person against which the compulsory license is awarded. So the dependent patent, the owner of the dependent patent, should be awarded a cross-license from the other party whose patent is unable to be worked in the country. So they should both be allowed to cross-license their inventions to one another. Kangwelo, you have a question?
Yes, Marco. Is it possible that you can give a practical example of the dependent patent, if possible?
Yes. Look, I haven't dealt with one myself in practice before, but if you think about a cell phone, for instance, okay, there's a lot of chips within a cell phone in order to allow the phone to perform its function. It could be that Intel Corporation is the developer of the chip and they own the rights into that chip. And Samsung holds the rights to the rest of the technology in the cell phone, but they're unable to actually make use of their patent without the chip. So they need the chip in order to work their patent. And in that case, they would be able to request the compulsory license to be issued to them so that they can make use of Intel Corporation's chip. Does that make sense? I think that's the most practical example to give.
It's very clear now, thanks.
Okay, yeah. So it's where there's, an amalgamation of different technologies, but the one can't work without infringing the other, because Intel will have a patent in this example specifically for the chip of the cell phone, and Samsung for other components. And this happens a lot specifically in this type of technology across the world. I've often heard a joke where people say when you're buying an Apple, you're actually buying a Samsung because so much of the technology is being licensed from Samsung. So just a joke. I don't know how true that is, but that's what happens. These companies actually cross-license a lot of their technologies. Okay, then just so that you know as well that you are not able to assign the patent when there is a compulsory license for dependent patent unless both of them are being assigned together. This slide, I'm going to leave this one out for today. This is for your own leisure and your own reading, where that deals with licenses of right. Just to touch on licenses of right, this is where the owner of the patent can endorse the patent register as a license of right. And what that means is that anyone in the public can then approach that licensor to obtain a license. So it's basically an advertisement for you to contact the patentee and ask them for a license, should you so wish. So you're endorsing it as a license of right that anyone is then able to make use of that patent. Again, the benefit of a license of right is that you won't be required to pay the full amount of renewal fees. It's only half the official fees, if I remember correctly. Okay, but these sections on this slide, you can read through these in your own time.
Marco,
Yes.
under the license of rights,
Yes.
the license terms would still have to be negotiated with each potential licensee, right?
As far as I know, yes. Yeah.
Okay. Okay.
I don't think we touch on this expressly here, but as with an assignment agreement where the patent has been assigned, it is advisable to record a license as well on the patent register, because again, then that's only effective between those parties that are party to the license agreement and not to third parties. And you also again have to request late condonation of the recordal of the assignment, should you record it after 6 months after the effective date of the assignment. Another important thing to note as well is that if a licensee is recorded as a licensee on the patent register, then the patentee has to notify the licensee if they wish to institute infringement proceedings. So if the patentee decides to institute infringement proceedings against another party, they have to give notice to the licensee, and the licensee can then join the infringement proceedings as a co-plaintiff as well. So just something to note there, in addition to what we've discussed with licenses. Okay, in terms of Section 90, Section 91 provides for exclusions from a license agreement. So these are provisions that you cannot contract into in terms of a license agreement. They are prohibited and deemed to be null and void. And there are 5 of these provisions that you are not allowed to include in a license agreement. So again, those working in tech transfer or drafting contracts, it is important to note the provisions of Section 91, and that these provisions are excluded in terms of legislation and are deemed to be null and void. And this is where there is a clause in the license that prohibits or restricts a licensee from purchasing or making use of an article which is supplied by a third party. So you can't prevent the licensee from making use of a third party's services or products. That is not permitted in terms of Section 91A. Section 91B, sorry, then also prohibits or restricts the licensee from using any article or process that is not protected by the patent. So you can't restrict somebody from only using products which are subject to the patent. That is also not permissible. Then the third provision is that you cannot require a licensee to acquire any article from the licensor other than that which forms part of the patent. So very similar to the provision above as well. So the one is actual use and the other is the acquisition of an article which is not protected by a patent. Then fourthly, the licensor is not allowed to specify a minimum resale price in respect of the article or process that is subject to the patent. So they cannot set a minimum resale price. And then they're also not allowed to restrict the licensee from making use or exercising the rights to the invention in a country where there is no patent protection for that specific invention. So say the patent exists in South Africa, but there's no patent in Botswana. They cannot restrict the licensor from making use of the invention in Botswana. And that is because you cannot extend your rights out of the territory of South Africa unless you have actually acquired those rights in terms of that national legislation. Okay, so just 5 important provisions to note in terms of license agreements and the clauses that are expressly forbidden from being included in those or are deemed to be null and void. Okay, section 92, I'm also going to leave that up to you to work through, and then we can move on to the restoration of a patent. So if I recall correctly, Wasim, you asked earlier this morning what happens in the case of the lapsing of a patent. Is there any recourse to the patentee, or is a third party in the public now able to make use of that invention which was otherwise subject to the patent?
Yeah.
Yes, and that's where this topic comes into play, which is the restoration of a lapsed patent. And in terms of section 47, it is possible to restore a lapsed patent. So where the patentee has failed to pay the renewal fees within the prescribed time period. So within, the 3rd year from the filing date of the application or annually thereafter. And they haven't paid it within that allowed 6-month grace period either, then the patent would have lapsed. So if they have failed to pay those renewal fees, even within the grace period, they are able to request the restoration of the patent by lodging an application to the registrar of patents. So remember, a lot of the other things we've dealt with have been applications to the commissioner or proceedings before the commissioner, but for a restoration of a patent in terms of section 47, it's an application that's made to the registrar of patents. So he has the discretion to allow the restoration of a patent. But in that application to the registrar of patent, 2 requirements have to be met in order to be successful in restoring the rights of the patentee to that patent. And the first one is that the omission to pay the renewal fee must have been unintentional. So in a situation where the patentee finds that their patent is no longer of economic value and they therefore are going to allow the patent to lapse because it's not of any use to them at this stage and they fail to pay the renewal fees, that is not an unintentional omission. Okay, so it must be a case where that failure to pay the renewal fee was unintentional. So in the case of a renewal reminder not being received by the patentee, so there might be a failure in the communication system where they didn't receive the renewal reminders, that would most likely be considered an unintentional omission to pay the renewal fee. Okay. But then also very importantly, and people often fall foul of this provision, is that as soon as the patentee becomes aware that their patent has lapsed due to the non-payment of the renewal fees, they must take prompt action in making an application for the restoration. And that is because the second requirement to be successful in the restoration of the patent is that there must not have been any undue delay in bringing the application for the restoration. Okay, and these are all provided for in terms of section 47.2. So if you have a look there, just to recap and to read through the section, it says if the registrar is satisfied that the omission was unintentional and that no undue delay has occurred in making the application, he shall advertise the application in the prescribed manner, and thereupon any person may within such period give notice to the opposition. So you can see there's quite a bit going on in section 47.2. The first sets out the requirements in order to be successful for the registrar to advertise the notice or the intention to restore the application, but then he needs to advertise it in the patent journal and give notice to the public, because they are also able to oppose the restoration of the patent, and they need to then make opposition for the restoration should they so choose. But if there is no opposition, and just before we jump the gun, the opposition period for within which to respond to that notice is a 2-month period. So the same as with an amendment, a post-grant amendment, there is a 2-month period within which to oppose the restoration of the patent. But if there is no opposition to the restoration, the Registrar of Patents will then issue an order that restores the patent. Or if he so chooses, he may also dismiss the application if he finds that those requirements have not been met in terms of it being unintentional and that there was no undue delay. However, if there is notice given to the opposition of the restoration, then that should be heard before the Commission of Patents. So it moves out of the jurisdiction of the Registrar of Patents and is then heard by the Commissioner of Patents. So if there is the objection, the Commissioner will then decide on the matter and either restore the application or dismiss it. So 2 scenarios, yeah, if there is no opposition, the registrar can deal with the issuance of the order or dismissal of the application. But if there is opposition, then it falls within the realm of the Commission of Patents, who will then decide on the matter. Canguelo, you have a question?
Yes, Marco.
Yes.
What could be the likely objection by the third party? Will they have to prove the unintentional and the undue delay?
So it is possible that they can object it on that basis, but it can be any reason that they might find. So it could be that they have expended a lot of money in now setting up a factory, as an example, in order to make use of the process that is subject of this patent, and it will be prejudicial to them. So it can be any real reason that they feel that it will be prejudicial to them. So it doesn't have to be on reliance of the unintentional or no due delay inquiries, but it can be any reason they might feel the need to oppose the restoration of the patent. And it will have to be some prejudice to them, to that party.
Thank you, Mark.
Okay. Before the issuance of the order, there obviously has to be the payment of all the outstanding renewal fees. So you need to ensure that all the renewal fees are paid and that they are up to date in order for the notice of restoration or order of restoration to be issued by the registrar. Section 47.1, okay, says that you apply for the restoration after the 6-month grace period. That's quite obvious. But how do you go about making this application? And that is set out in regulations 49 to 51 of the regulations, where it said that the application is made ex parte, so there are no other parties to the application. It's only the patentee that will make this application, and it must be made in a manner which mirrors that of a notice of motion in terms of the Uniform Rules of Court. So it just needs to mirror as near as possible a notice of motion. And that is then accompanied by one or more affidavits setting out the facts as to why you are requesting the restoration of the patent. From a practical point of view, it is advisable in practice for the party that is aware of the facts to make the affidavit and attest to the averments within that affidavit, and not to get the attorney to do it. You can have the attorney draft a supplementary affidavit in addition to the founding affidavit, or, so that there is a supporting affidavit to what is being averred in the founding affidavit. But it is always the party that is aware of the facts that should make this averment. And in that application, you obviously need to attest to the omission being unintentional and that there is no undue delay. So you need to show and prove that those two requirements are being met. And then you need to pray for the registrar to restore the application. So very similar to what you would use in court. You would aver these and include these prayers in the application to the registrar. Okay, so quite straightforward, setting out, who you are that is making this affidavit, what your position is, why you are bringing this application, and setting out clearly what the facts are that led to the lapsing of the patents, and that it was unintentional and that there was no undue delay. Okay. And again, just section 47.2, setting out the requirements that need to be met. This we have touched on all already. It's just set out per section, but we have touched on all of this. Okay, but what happens, and this is what William was asking about this morning, is what happens to the rights of the patentee once the patent is restored? Are his rights limited in some way? And in terms of section 48, it does seem that there is some limitation of the patentee's rights here. Because if you look at section 48.1, it states that a patentee whose patent has been restored may not institute any proceedings or recover any damages from any person who would have otherwise infringed the patent during that period within which it was lapsed. So during that lapse of that patent, so say the patent had lapsed for 2 years, if somebody had started using the patent or the invention which is subject to the patent, the patentee cannot institute infringement proceedings from that party or recover any damages from them. I mean, they were rightfully entitled to do so. Or from any person who has used or offered to dispose of or disposed of any article or imported the article during that period as well, or who during that period also commenced using or exercising the invention to which the patent relates, or who thereafter continues to use or exercise the invention. Now that's quite a tricky one, because yeah, it says who continues to use or exercise the invention. So once those rights of the patentee have been restored, is that person that was making use of that patent during the lapse period allowed to continue to do so? It's quite a tricky one. I think it's quite an onerous or unfair burden on the patentee, because that person basically has the right to continue exercising or using the invention for that patent. However, it goes on further to say, or uses or offers to dispose of any articles or products produced by the continued use referred to in subparagraph 1 above. So quite difficult, and this is again a provision that's quite debatable in practice as to whether that is the intention of the legislature, to allow for the continued use and exercise of the invention once the patentee's rights have been restored. Then section 48.2 goes on further to say that any person that has expended money or time or labor in view of exercising the rights which they would otherwise not be allowed to during that period within which the patents lapsed, they may apply to the commissioner requesting compensation in respect of the money or time or labor that they expended. So you can see it's very important to make sure that you don't allow your patent to lapse, because you can end up in a lot of hot water where people are allowed to continue to use or exercise the use of the patent, or to recover compensation from the patentee for the expenditure of time or money or labor during that period. And then the commissioner, after hearing the parties, will assess the amount of such compensation, and if in his opinion the application ought to be granted, and the time within which such compensations shall be paid. So that just gives the commissioner the rights to make that assessment and to make an order for the compensation. So you can see quite a very harsh section, this, and quite burdensome on the patentee should they allow their patent to lapse unintentionally and to have it restored, because there is recourse against them where somebody would has set up a factory, in this case as an example, to recover those costs. Okay, is everyone happy with the restoration of a patent? Okay, it seems. Any questions? Thanks for the thumbs up there. Untatile, you have a question for us? Hi.
Yeah, can I just ask, that opposition period you spoke about for the restoration application, what is it again? I just missed that.
That's a 2-month period.
2 months.
Yes.
Okay, thank you.
Pleasure. Okay, if we move on to the next section then, which is the revocation of the patent. And this would occur when another party or any person wishes to attack the patent on the basis of its validity and would try to revoke that patent so that it is no longer in existence, so to speak. So any person may apply for the revocation of a patent, and there's no real need to show any interest, but I don't know why you would try to revoke a patent if you're not really interested in making use of it. And the application for revocation may be brought at any time from the date of grant of the patent up to the expiry and even after the expiry of the patent. So at any time a patent can be revoked. It was held in the Busby case versus the Registrar of Patents again, that the grounds on which a patent can be revoked is exhaustive. So it's only those grounds that are provided for in the Act on which a patent can be revoked. You cannot introduce any other grounds on which to revoke a patent. It's simply those which are set out in section 61 of the Act on which you can revoke a patent. Always important to note, if you are instituting infringement proceedings against a party for the infringement of the patent, that defendant can counterclaim for the revocation of the patent, or can rely on the grounds of revocation as a defense. And this happens in most instances during infringement proceedings, where the other party, the defendant, will then also apply for the revocation of the patent and saying, look, I'm not really infringing on the patent because it is invalid on the grounds which are listed in section 61. So this is just a very important section for you to note as well. I think in all the years of this subject, there has been a question on the revocation of a patent. So important to know the grounds on which a patent can be revoked. So just make a note of that, please. But the first ground on which a person can rely on is that the patentee is not actually entitled in terms of section 27(1) to apply for the patent. Section 27, if you may recall, we dealt with that not too long ago. That held who may apply for a patent. So it is the inventor or the person to which the invention had been assigned to, or any predecessor in title. So that is the first ground on which you can invalidate or revoke a patent, is where it is alleged that the patentee is not actually entitled to the patent. So it could be that somebody applied for a patent, but they weren't actually entitled to do so. They didn't have the rights to the invention to file that application for a patent. Then secondly, it would be where the grant of the patent is in fraud of the rights of the applicant or in any other person under whom he claims. So where the rights to the application were obtained in a fraudulent manner. I'm not familiar of any situations where this has occurred before, but do be aware of it. And then probably the most important ground that is used in the attack regarding the validity of the patent is that the invention is not patentable in terms of section 25. Now you may remember that section 25 dealt with the list of inventions which are not considered patentable, and if you may recall, it was the discovery, a scientific theory, mathematical method, computer program, presentation of information. But not only that, also the method of treatment or the development of a plant or animal variety. So those all fall under the ambit of section 25. So quite a lot that goes on within section 25 and which you can invalidate or revoke the patent. And then also most importantly, that the patent lacks novelty, that the patent is not inventive, that it is not capable of being used or applied in trade or industry. So a lot of provisions in terms of section 25 on which you can attack this patent, and that it should not have been patentable in terms of the provisions of section 25. Okay. Then the fourth provision that you can rely on in the revocation application is that the invention as illustrated or exemplified in the specification cannot be performed or does not lead to the results and advantages set out in the complete specification. So this is a situation where the complete specification doesn't clearly define what the invention is and how the invention must be performed or work. So you haven't provided enough information in the specification to allow somebody that is skilled in the art to actually perform the invention. So it is basically an incomplete specification. And this provision is known as inutility, where the patent is inutile because it doesn't set out or illustrate or exemplify how to perform or work the patent or the invention subject to that patent. And it's also very important to note that it goes further to say that it doesn't lead to those results or advantages which you have claimed in the specification or set out in the specification. And you'll often see when patent attorneys draft a patent specification that some will include the advantages of this invention. What am I achieving by this invention? The advantage might be that it cures cancer, as an example. But when you do these tests, it doesn't actually cure cancer. It might just bring it into a remission state. So you're not really achieving the advantage that you have claimed, and that can then lead to the patent being invalid. So it's very, you have to be very careful when you draft your patent specification not to make claims that the invention leads to very specific results or advantages, because you can attack the patent on that basis. Okay, if we look at the fifth provision, it is that the specification does not sufficiently describe, ascertain, illustrate, or exemplify the invention in the manner in which it is to be performed, or to enable the invention to be carried out by a person skilled in the art. So very similar to the provisions of 4 above. So the one is the inutility and the other insufficiency. We haven't sufficiently disclosed how to perform the invention. If we move on to the next, then, is that the claims are not clear or fairly based on matter disclosed in the specification. And as you remember from the amendment section as well, your claims have to be fairly based, or any amendment to the claims has to be fairly based on the specification. And again, it's reiterated here that your claims have to be clear. There can't be a clarity issue as to what it is that you're actually claiming, and that it also needs to be fairly based on what is in the specification. Then if we move on to the next section, you'll recall that I mentioned yesterday that the Form P3 and P26 are very important documents, and that the patent can be revoked if those declarations that are made in terms of the Form P3 and P26 contain a false statement or representation which is material and which the patentee knew or ought to have known. So very important there. He might not have been aware of it, but he ought reasonably to have known that the declaration being made is false. Then the patent can be revoked on this basis, in terms of the false declaration being made on the P3 and P26. Okay, remember the P3 relates to the certain averments that the person is the applicant, that there is no lawful ground for the revocation of the patent, that the inventors are who they say they are, that the claim to priority is correct. If any of those declarations is false, or the patentee should have known to be false, would be considered a material misrepresentation, and the patent can be lacked. Whereas the P26 is where you avert to the invention relating to biological material which is indigenous to South Africa or not. So if you are making a declaration stating that the invention does not relate to South African biological material or indigenous knowledge, but it does in fact, then the patent is also open for attack. If we move on to the next point, point H, this is that the application for the patent should have been refused in terms of section 36, and that is where the registrar should refuse the application on the ground that it is frivolous, it is contrary to natural laws, that it can encourage offensive or immoral behavior, and also remembering the nuclear energy provisions. So you must have complied with those provisions in terms of the Nuclear Energy Act. But again, this was as we said yesterday, this was a very difficult one to prove. You know, it's so subjective as to what is considered offensive or immoral. But I'm sure it would be easier to ascertain that it's contrary to well-established laws. As we said, an example being the invention for perpetual motion machine. And then the last ground on which a person can rely on is that you haven't complied with the requirements of the Budapest Treaty. So you haven't provided the accession number or documentation relating to the microbiological deposit where you're claiming an invention of a microbiological process or a product thereof. and there should be a deposit made available to the public. So if you haven't complied with those provisions, then it is also possible to invalidate and revoke the patent on that basis. You'll recall when I was dealing with the divisional applications this morning that the Act does state that a patent shall be granted for one invention only, and that is clear here from section 62. But it goes on further to state that no person may in any proceedings object to a patent on the ground that it comprises more than one invention. So in South Africa, you can't revoke a patent on the basis that it comprises more than one invention. Okay, in the instance where the patent is revoked on the ground that the rights were obtained fraudulently, so if the party relied on 61B, where they're revoking the patents on the grounds that those rights were obtained fraudulently, the commissioner has the discretion to assign those rights, or basically to hand the patent over to the party who was rightfully entitled to obtaining the patent. And I think that will be it for now. Are there any questions on the grounds of revocation? Hi, Lufuno.
Hi, Marco. How are you?
Well, and you?
I'm good, thanks. Marco, so in terms of family patents, how does it work in contrast to Section 62?
Sorry, I didn't hear that initial part. You said in family patents.
Yes, because we have some patents that you say these are the family patents, and then I need a clarity on that. What is the family patent? How does it work with Section 62, something like that?
No, so Section 2 is where the invention itself, so the disclosure in the specification relates to, let's take the example of the mug again. So say this mug has never existed before, or any component of this mug, and the disclosure is for the body of this mug, and then there's also the new invention for the handle. So this has never existed before. It's a very arbitrary example, but you'll see that that application has an invention for this mug and also an invention for the handle. So that is the situation where one application comprises two separate inventions, okay? And that's where you would file your divisional application for the invention directed to the actual body and one towards the handle. But a family of patents is just that those patents are all related. So where there is patents for the same application, or rather applications being filed for the same invention across the world, they're all related, they form part of a family. So that's what they mean by a family of patents, is that it's all for the same invention, but in different jurisdictions and territories. Does that make sense, Lufuno?
Yes, thanks.
Okay. But say the application for the patent, or the patent that discloses this body of the mug and the handle, you can't revoke the patent because it comprises both of these inventions, unfortunately. Are there any further questions relating to the revocation of a patent? Okay, so I mean, the provisions are quite clear. You can do a bit more reading from the Dean and Dyer if you so choose. But like I said, the provisions are quite clear, and those are the only provisions that you can rely on in terms of the Busby case. I think we shall break for another hour for lunch, and then we'll reconvene at 1 o'clock. We don't have much more to get through. It's only the section on infringement because the last sections are for self-study, and then we'll work through the examination papers. So we might actually finish on schedule today, all right? But we'll see how it goes. If you do have any questions, please feel free to ask me, or we can address them when we get back from lunch. Okay, so see you all at 1 o'clock again. Enjoy your lunch and go stretch your legs and have a good break. See you shortly. Bye. Hi, Michaela. I see you've just joined the meeting, but we're breaking for lunch and we'll reconvene at 1 o'clock again. Yeah, welcome back, everybody. I hope you had an enjoyable break and are ready for this last stretch for the day. We might still take a short break in between, but we'll see how it goes. So just to recap, we dealt with the revocation of a patent before we broke for lunch, and that is where somebody would like to invalidate the patent. Now we're going to look at it from the patentee's perspective, where they wish to institute infringement proceedings in a case where they believe that a defendant is infringing on their rights granted in terms of the patent. But before we head off into the section, are there any questions that you may have thought of during the break that we had with respect to what was discussed earlier today? Okay, it doesn't seem that there are any questions, so then we can jump into the infringement section. So we've spoken a lot about a patent and what it is that a patent is, and that a patent grants you a monopoly and a negative right, as you'll recall from yesterday. I mentioned that the right that is granted to you is a negative right, in that it provides the patentee the right to exclude other people from performing certain acts. And this is dealt with specifically in section 45, where it mentions what the effect of a patent is. So what is it that this actual right is that is granted to the patentee? So if we have a look at section 45(1), it mentions that the effect of the patent shall be to grant to the patentee in the Republic. So remember, it's a territorial right. So these rights only extend within the borders of South Africa. For the duration of the patent, as you'll recall, that's a 20-year duration, the right to exclude other persons from making, using, exercising, disposing, or offering to dispose of, or importing the invention, so that he or she, the patentee, shall have and enjoy the whole profit and advantage accruing by reason of the invention. So as you can see there, the right that is granted to the patentee is the right to exclude others from either making, by way of manufacture, or using the invention, exercising, disposing of, that can be by way of sale or even by donation, or offering to dispose of, so by marketing and advertising the product for sale, or importing the invention. So those are the rights that the patentee has, in which he can exclude others from performing one of those acts. If somebody does make or use or exercise the invention that falls within the ambit of what is disclosed in the patent, then they will be committing one of the acts of infringement, or more than one act of infringement for that matter. So these words, as you can see, they are quite broad in terms of making, disposing, but you can assess that on the dictionary definitions, which you'll see is provided for in the slide over here. I'm not going to go through that because it is quite straightforward, and you can have a look as to what each of those acts of infringement specifically mean, and what acts would be considered an act of infringement. If we then move on to section 45(2), section 45(2) provides for the exhaustion of rights. So it states that the disposal of the patented article by or on behalf of the patentee or his licensee shall, subject to other patent rights, give the purchaser the right to use, offer to dispose, and dispose of that article. So that just says that once the patentee or the licensee has disposed of the patent, whether by sale or offered to dispose of, then those rights are exhausted, and the purchaser of that article can do with it as they deem fit. But who can bring an action for infringement? Well, obviously it is the patentee that can bring the action for infringement. But you may recall earlier as well that the licensee, if recorded in the patent register, is also allowed to join the proceedings as a co-plaintiff. So the licensee doesn't have an independent right to bring the proceedings themselves. But the patentee, if they do wish to proceed with infringement, excuse me, but if the patentee does wish to proceed with infringement proceedings, he has to give notice of his intention to take action in terms of an infringement action to every recorded licensee. And that's why it's so important to ensure that a licensee is recorded as such on the patent register. Are there any questions so far? So if the patentee does bring the action for infringement, yes, Lufino, you have a question?
Yes. Marco?
Hi, Lufino, yes?
Yes. Yes. I have a question on the previous slide.
Okay. Sorry, that way?
Yes. On the local standing.
Okay.
I think a little bit of I think I didn't get I didn't get it right on the second bullet.
Okay, so
I'm struggling to digest that information.
Okay, so what the second bullet relates to is it says that the licensee, so if there is a licensee, where the licensee has been given the permission or consent to use the patent in South Africa, the licensee can't bring an action for infringement themselves. It's only the patentee that can bring an infringement action to the court. However, in a case where patentee does bring an infringement action, they need to give notice to the licensee, and the licensee can then join in on the proceedings. Does that make sense, Lufino?
A lot. Thanks, Marco.
Okay, perfect.